A very warm welcome to the fourth edition of Turnip's IPR Career Summit 2026. This year we have Qualcomm and the L2Pro India platform supporting the event. The theme of the event is opportunities as a registered patent agent. Patent and trademark agent exams are scheduled for January 2027. You can still register for the exam till 30th of September. That is why we thought that it would be a great opportunity to discuss career opportunities in the IPR field in general and as registered patent agents with the IP India office. The goal today is to learn about patent careers and details of the patent agent exam. We have two eminent speakers for this event, Nitin Sharma from Qualcomm and Prachi Pandey from Maharashtra State Education Society. So first up is Nitin Sharma. He is the Senior Director and Technology Counsel at Qualcomm. He is joining us from Hyderabad, I believe. So folks, please give a round of applause on the chat and make sure to ask questions and really use Nitin's time today. So thanks a lot, Nitin, for your time. Really appreciate it. So please, the floor is yours. Basically, I think we can start with the first question, like how do you see IPR careers growing and so on?
Good evening, Rahul, and good evening, everyone. Just a quick check. I hope I'm audible and we're good.
Yeah, it's great.
Cool. So I guess patent agent. So first of all the best to all the aspirants of patent agent 2027 exam. I guess, in my opinion, I don't think that the patent agent merely draft patents, right? And it's basically patent agents are going to be innovation advisors, business strategists, AI-enabled analysts, and policy influencers. But let's say, what do we see the future of IPR in India, right? I would say let's look at what's happening in the technology landscape in India, right? Two ways to look at it, right? One from the patent law and IP point of view, and the other one is from the technology landscape point of view. If you look at the patent landscape in India, we are fairly new country. It was in year 2005 when the laws became aligned with the global patent laws, right? And since then, it's been a great journey in India. The second phase of growth in patent and IP activities in India was from 2016 onwards, when the Patent Office embarked upon reforms and improving efficiencies, etc. Also, around the same time, there was a lot of focus on startups and innovation and IP creation, so to speak, right? So, the patent law journey that we see in India is basically is happening at a great pace, and we expect the reforms to continue and this ecosystem to grow. If you look at technology landscape, right, India is actually experiencing a lot of growth in startups. You will see a phenomenal increase in the number of startups that have come in. We are also seeing a lot of focus on deep tech now. Of course, in startups, the initial flow was more on the services and software side, but as we speak, we see a lot of focus on deep tech startups. And if you have followed the recent launch of rockets by Skyroot, you'll probably agree with me on this. There is a lot of growth in AI space. There is a lot of focus on semiconductor space. If you see, there is a lot of focus on 5G and 6G related innovation and IP development in India. Likewise, biotechnology, clean energy, electronics, devices manufacturing. I can go on and on, right? Automobiles, electric vehicles, and things like that. So you will see that there is a lot more focus on technology innovation in India, and there is an aspiration of creating homegrown technologies, etc. Now, every innovation-driven economy, if you see, requires protection of innovation, and that happens through your intellectual property protection mechanisms, right? So you're looking at various types of IP and protection. So you also are looking at a cohesive strategy around intellectual property, right? You're looking at freedom to operate analysis. You're looking at collaborations with the innovators globally and locally. You're looking at licensing. You're looking at enforcement of IP and all of that, right? So if you are talking about innovation economy, you are talking about intellectual property, and then you're talking about all these aspects of intellectual property, which by default means that we will need IP professionals, right? So the demand curve for innovation is moving upwards, and therefore the demand curve for quality IP innovations, IP professionals, is also moving upwards, right? The other way to look at it is 20 years ago, most patent professionals worked in the IP law firms or the firms which are filing patent applications. But today, you see opportunities existing in corporate IP departments. Uh, all the big innovator companies that you name, you will have a good IP department in it. And the roles around that involves patent prosecution, portfolio management, patent mining, dealing with standards, licensing, litigation, all of that. You also have roles around patent analytics, which basically helps innovators and the implementers alike analyze the portfolios, technology trends, landscapes, and things like that. Right. You also have IP consulting, wherein you might be advising the startups, universities, incubators, etc. And then there is also focus on licensing and monetization. I mean, if you see what's happening, lately, you will see that there is, a lot of focus on commercialization of IP that's being created, whether it's through startups, whether it's being created in the academic institutes, or it's created by companies, right? There is a lot of focus on how we can improve the commercialization of IP which is being generated in India. So, all in all, I would like to say that there is a lot of the pace at which the technology is evolving and the technology landscape in India is evolving, and the focus on innovation is increasing. You will see increasing opportunities around IPR in India. I'll pause here, Rahul, and see if you have any comments or thoughts there.
Yeah, I'll tell the audience upfront that I think we can start taking questions like as and when a good question arrives. So please feel free to write questions in the chat. I'm going to selectively pick them up. And meanwhile, I'll ask a few questions and, let's see, so that we learn more about the patent agent as a profession, as well as IPR in general. So how are IPR jobs currently structured? That was my one question. And do all jobs require becoming a patent agent?
So, okay, let's look at how the jobs are currently structured, right? So I did allude to it a little bit in my previous comment, but let's say today, if you really see, there are about 5 major buckets. First one, the law firms, right? So if you see various IP law firms, the boutique IP law firms, especially around patents, you'll see drafting as one of the roles. You work with the innovators and draft the patent application. And then you have prosecution of that patent application, which means you will work with IP office and ensure that your patent application gets approved by addressing the objections raised by the patent office. of course, and there is an opposition dealing with opposition to those applications, etc. The law firms also advise clients on these matters, right? When you deal with patent prosecution. So one of the things that one of the roles that you will have in the law firms will be around patent prosecution, the drafting prosecution, and also when it goes to the litigation, then you will have attorneys who fight the cases for you in the court. The second bucket would be the corporates, where you would work with innovators who and then work towards developing or building a patent portfolio, right? So so that's a very important job, because you as an IP professional would basically be helping them and ensuring that the portfolio is well structured and a strong portfolio. You would work with them on harvesting the inventions, identifying what should be protected and what should not be protected, and things like that. You will also deal with global prosecution, which means not just in India. You will also be looking at how your inventions can be protected in other jurisdictions, and of course, licensing support. Ensuring that your IP is licensed, or if you are licensing out, then you will work towards that. And lastly, ensuring that your IP is not used without your permission. You will also be supporting on the litigation side and infringement analysis, etc. So corporate roles offers you this kind of variety of work and roles. The third is the services companies, or the knowledge processing out KPOs, as we say. So you basically provide services for patent searching, invalidity analysis, landscape studies, and various sorts of analytical services, right? So a lot of those companies require IP professionals in that area. Then you have big companies like KPMG and others, who provide consultancy and advisory to large and small companies, or on IP strategy, building, doing due diligence, doing valuation in bigger transactions, and also advising startups on how to build a good IP strategy as they grow, right? So consulting and advisory becomes a big area as well. And lastly, but not the least, in the areas of policy, research, and academia, I think you will see a lot of interesting work happening in the government policy area. There are think tanks right now who are basically looking at the lens at the ecosystem and trying to see what are the issues, what are the challenges, how we can overcome those, and provide recommendations to governments and to companies, to innovators, to implementers, and all that. Universities, again, are a great place for building a good IP career. And lastly, something which we are really trying hard to build in India is the technology transfer offices. I think it's an amazing role to play, because here you would work with the university innovators and trying to work with industry partners, and sometimes create the startups and things like that, to make sure that the technology that's built in the university is actually university or R&D labs actually gets commercialized, and society gets benefit of that research. So these are the 5 major bucket areas, I would say, where you will find the jobs, or rather the jobs are structured in the industry. Yeah. What was the other question, Rahul? Sorry.
I think it was related, like which kind of jobs would absolutely require becoming a patent agent, and which ones would be like.
Yeah. Okay. So I think, I would say a degree or a certification like patent agent certificates is important, because that certifies that you have a knowledge in a certain area, right? But you all know that graduating from a university with an engineering degree does not, it gives you a seat on the table, right? Which means the companies will hire you, but then you really require a lot more than just the basic degree to succeed in the industry, right? Whether it's engineering, whether it's any profession for that matter, whether it's a medical profession you've chosen or likewise, patent agent certification gives you a seat on the table where it says that, hey, you are a person who has a knowledge on patent law, prosecution, and nuances around it. Now, it's critical because without that, it's very difficult to get into some of these roles. Of course, if you are in a company or if you are in a law firm which gives you an opportunity to learn as you go, you can still work on these areas without a formal certification. But in order to appear before patent office, you need the patent agent certification, right? So that's a building block. That's a starting point, right? So you definitely need a certification because it gives you statutory recognition, right? As I said, but so yes, it is important. But then once you have that certificate, it's you who, or rather, it's your personality that you bring onto the table along with that certification. And there are so much variety in what you can do after you have that certification. We discuss some of those aspects, right? From drafting to analytics to licensing, which is basically the business negotiations, to valuations, and so there is a huge plethora of options that you can choose from once you have this basic degree and go from there, right? So when I say you bring your personality onto the table is where what your interest lies and how you want to build it. So it's a very important thing to have. So definitely one should try to get the certification if you want to play a role in this space.
Yeah. We have some first questions coming in. So fear not. Is there any specific certificates to obtain in order to land such job roles? Probably mentioning some roles that you mentioned, like WIPO is providing, or is there any pathway? Can you put some light?
Yeah, no, I think it's a good question. So I think if I were to start building my skill set in this space, right? I think there are 2 or 3 uh, degrees or courses I would look at, right? So one, of course, is the patent agent certificate. That's key. As I said, that gives you statutory recognition. I would say it all depends on which direction are you going to take, right? For example, if you want to play a role in IP valuation, right, you must be aware of various economic concepts or economics concepts which are required to understand how the valuation works, how market dynamic works, right? What are the ways to assign a market value to a certain technology piece, right? Which means you need to know how to do a market analysis of a particular product, right? Let's say if you want to sell a new product that you have created, you want to do market analysis. You want to see how much customer is willing to pay for it. Is there a market at the first place? If there's a market, what could be the ideal price point wherein the customers would take it, and things like that. IP is as a product, right? It's just like as good as any other product, and you need to know what's the market for it, who's willing to pay how much, and how long will it take to get that product in the market, and things like that. So you need some of these basic concepts which are not IP specific, but related to these are the skills or the concepts that you need to understand to do a good valuation. So then you will need certifications, or you need to do courses which helps you build that expertise. If you want to play a role in the litigation or enforcement side, I think doing a regular LLB is a great option. Because what it gives you is that it gives you an opportunity to appear in the court, right? And then if you have a patent agent certification and you have LLB, then you have a skill set or a required certification to to play a role right from the creation of IP to enforcement, right? So you get the whole spectrum of it. If you combine it with your MBA, it becomes a business marketing, IP marketing, right? So you could basically play a role in promoting sales and marketing of your if you of your product, right? So just like, you know, in an engineering role, you could choose a role by getting into product marketing, or a technologist, or a salesperson. Likewise, in case of IP, also you can play all these multitude of roles. And what additional certifications or degrees or a skill set you require depends on what you want to do in this, right? What's your natural style, right? I think not everybody can be a great negotiator, right? If you have that flair, if you like enjoying the negotiations, then you probably look at the courses or certifications that help you learn more of that. So I hope that gives you an idea. But I would say, the beauty in this field, which I like, is that you can do a lot many things based on your own interest and preferences, and I think you can chart your own course here. So if you ask me about specific role within IP, and then I can help you more with specific suggestions on what courses you might or you should take. But in general, I would say, depending on which path you want to take within the IP professionals domain, you can choose to take courses according to that.
Yeah. I mean, Turnip, we have 30 courses on IP, and people always ask me, like, इससे हो जाएगा तो मतलब they just want that one course जिससे कि सब हो जाएगा, but there's no such course जिससे कि ना सब हो जाएगा. So we have a course on IP and ethics and AI ethics and IP. अभी एक नया course we have launched. So it talks about these things like personality rights, voice cloning, these kind of modern concepts. We have a course on patent analytics, patent strategy, but all are going in different directions. There's no like one course
Yeah.
won't like.
I would also like to add that it's a very interesting field, because it's a confluence of your underlying IP area, which is the technology domain, or whatever it is. It could be pharma, it could be the ICT, it could be mechanics, or whatever it is, right? So that's one choice that you have to make, right? So you might have to have certain courses and certifications in that area. Then it's a law side. So you might have to look at how much you want to play in the legal aspects of this, right? Do you want to stick to patent agent part, which is more of a prosecution side, or you want to expand it to the litigation side as well and want to do law or LLB? And then the other aspect is the business aspect. Look, patent law is governed by Ministry of Commerce. And what most of the people miss is that it's a business tool, which means without a knowledge of business or business aspects, it's very difficult to succeed in this area, right? So it's a great combination of technology, law, and business, and you need to basically be versed with or comfortable with all these three areas. Not necessarily expert in all these three areas, maybe expert in one of the areas that you prefer, or two areas that you prefer, not necessarily all, but you need to have enough knowledge about all these three arms so that you can play a meaningful role in building IP strategy, or whatever area that you choose. I think you might need understanding of all these three to play a good or a impactful role in this space. Challenging but interesting.
Probably a good continuation. The next question: what are the best ways to monetize IP besides directly selling a product?
Okay, great question. Yes. So, well, it all depends on the owner of the IP about what he wants to do, right? What's his business goals are. And the answer to that question, what is the best way, would be determined by the IP strategy of that organization which holds the IP. And a good IP strategy requires an input from business strategy, the technology roadmap strategy of the company, from the HR, the financial strategy, and all that. What I'm trying to get to is that there is no one answer. It always depends on, as I said, it's a business tool, and a tool is as good as how you use it, right? So if I know what is the business priorities or the goal of an organization, I can then build a good IP strategy around it. And that will answer me or provide me with an answer on what's the best way to monetize my IP in my situation. Now, that's one way to look at it. But I can tell you there are a few ways of IP monetization available for anyone. And they can pick and choose depending on their own unique situation or their own unique goals, right? Um, One, of course, directly sell your IP to someone who wants it. Number two, license it. Either exclusive license, either non-exclusive license, or whatever way you want to do it. Within licensing also, you can choose to license it for an upfront payment or a regular recurring basis, and you can play around with it depending upon the best uh, interest of both licensee and licensor, right? You could choose to create a startup with that IP and try to directly build a product and monetize it, right? That could be one way to do it. You could create or become a part of pool to, you know, and let the pool commercialize it for you in different ways. So there are different ways of doing it, right? It's just, just think of it as a product that you have and you want to sell it in different ways, right? So when I say sell, I mean it is basically commercialize it in different ways. Um, you have companies who build a product and license it as well, right? So it just depends on how market dynamics are going to play and what's your primary goal as an IP owner. So you have these few ways to do it. Which is best depends on your IP strategy and business goals.
Yeah, yeah, yeah. Yashvardhan is asking, can try SIP certifications. Do you know about this? I mean, I'm not aware SIP certifications.
If you could elaborate on what you
Yeah,
mean.
please, Yashvardhan, if you can write it, I'll try to take this question again. One question is there. Okay, let's first take this. Bhanu asks, is this certification for LLB or people from technology background can also do? So
Yes,
probably they are mentioning the agent.
yeah. To join an LLB course, all you need is a graduation in any field. I have done engineering. I am a BTech in computer science and engineering, and then I worked as an engineer for a long time, and then I decided to join LLB, and I did LLB, right? So, yeah. So you need basically a basic degree course, and then you can join LLB.
Yeah.
You could be in
That,
art, science, or whatever.
yeah, that's for LLB. But maybe this person is asking for the patent agent, for which you do need a technical degree, any kind of technical degree, bachelor or. But of course, Prachi Pandey ma'am will take the session in the second half, and she will go through these things in a lot of detail, like if there's any age eligibility or is there any background prerequisites and so on.
Okay. Sure.
All right. All right. So, Anonymous, good evening. He says, I want to ask how far engineering background plays a role for in house roles. For example, do Qualcomm only work with electronics or other roles also? I think, in general, my question is also, if I can add it, it's how much specialization is needed. Because I think patent agent is rather diverse.
Yeah. No, I think great question again. I think, as I said, IP professional basically is a combination of three parts, right? Three skill sets. One is the the IP area itself, right? Or I don't want to use term technology because, or maybe you can use the term technology. You could have biotech, you could have pharma, or ICT, or whatever it is, right? So the core innovation area, let's call it this way, and then the law, and then the business part, right? So the core of the core skills, technology skills, becomes very important for IP professional. Again, it can vary from, how important it is. It is important, but how important it is can vary from the role that you want to play, right? So it is important because, let's say, if you are working in-house, I think the question is with respect to in-house. As an in-house IP professional, you will be working with innovators or researchers and engineers who are generating the IP, right? Now, if you don't understand that domain or that IP, you cannot collaborate with them as much. Of course, you can take it from the face value on what they say that is novel, or which is their IP, etc. But in order to process that information, you need to understand that background knowledge. You need to understand that technology and have that background. Then you can provide your own inputs in terms of how you can identify the assets which are important, and so on and so forth. So yes, engineering background plays a very important role for the companies who are doing, who are innovating in that engineering domain. If you are looking for pharma related companies, then your pharma related background becomes important. So depending on which company it is, which area they are innovating in, that engineering background becomes important. Companies like Qualcomm or Samsung or Ericsson or Mahindra or Tata's, they will all consider engineers or the IP professionals with background in the domain in which they want their IP to be protected, and all. So I hope that answers your question.
Yeah. All right. Moving on, I think Varun, he asks that he is already scheduled to appear for the patent agent exam, which is 10th of January in 2027. I want to remind the audience that 30th of September is the last date to fill the form on the IP India website if you want to appear for this exam. Could you guide me? I think question is about preparation. We have Prachi Pandey coming, but Nitin, if you want to add anything, please.
Sure. I think personally, I when I appeared for it many years ago, I think the NPTEL course on patent law was extremely useful. I think I really found that was very useful. I think basically I would say just look at like section 1 to 80 of Indian patent law and become a master in that. And once you do that, your first part of the paper is done, and then becomes the drafting. And I think there are a couple of very, very good books. If I remember right, Robert S. Slusky, or I think that's the name. Maybe I can look up exact name and tell you. I think that book I found very useful. Just focus on basics. I think if you understand why a particular section exists in the patent law, you will do good. And similarly, if you understand why patent law exists and how you should be drafting it, I think you can handle anything. So focus on basics, and these resources could be useful to you. And I'm sure there are a lot many resources would have come up since then. But I think if you stick to basics, understand patent law as a concept, and drafting, I think it should be good.
Yeah. All right. Interesting question from Anya. Can IP be transferred if the company shuts down?
Okay, absolutely a great question. I would say IP is not a different thing. What is IP is basically intellectual property, which means it's a property, right? And any concept that's associated with property is associated with IP. So if a company shuts down, all its property, whether it's real estate, whether it's machinery, cars or whatever it is, right, can be transferred, right? It gets sold or it gets whatever, right? Same thing happens with IP, right? It's a property, so you can always sell it to uh, person who is willing to buy it, and there are so many examples in the industry where the IP gets transferred, not only when the company shuts down. Of course, there are examples in which when the company shuts down, there is a sale of IP, but there are transactions happening uh, related to IP all the time, and you will have resources which shares you report on monthly report on what IP transactions happened, last month. So yes, it's all possible.
Great. Follow-up question from Fear Not. He says, I am a software engineering graduate pursuing law. Going forward, how can I benefit? Should I choose patent advisor or IP advisor? If you could elaborate on this.
So the way I understand the question is, you want to choose a patent advisor as a role, and you are asking how would that benefit to you, right? Is that the question?
I think, I mean, patent advisor versus IP advisor. That sounds like
Okay,
a
so
central part of the question.
okay, I'm assuming when you say IP advisor, you're talking about a broader role, and when you are saying patent advisor, you are trying to stick to patent law, right? Now, my take on this is that I would prefer being more focused within what type of IP I'm want to work on. So if it's patent, I would like to focus on patent. If it's trademarks, I would like to focus on trademarks, and if it's copyrights, I would like to focus on trademarks. And the reason is simple. Each of these is a very specialized area, and there's a lot happening in these areas. So then the question essentially becomes, do you really want to go deeper into one area, or you want to build a broader skill set and want to deal with it? But in my opinion, or in my observation, I see that industry prefers specialization. So you will not find many professionals who are both trademark professionals as well as patent professionals, right? And likewise, a copyright professional and trademark professional. You may find firms which deals with all kinds of IP, but they will still have people specialized in these areas working separately on this, right? Even in litigation, I see that litigators who, well, you will find litigators who deal with both copyright and patent law and trademarks and all that. So there you might find a bit more broad breadth, but yeah, it's basically a choice between how much deep you want to go versus how much broader you want to go. But let's say I find myself, I focus mostly on patents, and I find myself even 24 hours or less if I want to continue to build expertise in this area, because one, technology is evolving at the furious pace. We all know that. Patent law is evolving. A lot more is coming up, and it's trying to catch up with the technology landscape. Lastly, the litigation itself, or the policy itself, is a great area. I mean, it's very difficult to catch up with what all is happening in this. And then if you want to add, copyrights and trademarks in that mix, it becomes challenging. So again, it's a choice. If you want to be on a broader side, then you will probably have to give up on the depth side. One way or the other, both have its own pros and cons. You can choose, what is that you want to do, and accordingly decide on this.
All right. Fear not. Hope this answers your question. We have Divya Raman. She is asking, I have a degree in life sciences, and she is also preparing for the patent agent exam. She'd like to build in patent and IP field career. She has actually two questions back to back. So could you please guide me? So this is a general question, like guide me on building a career in IP patent with life sciences background. And then let me put up the follow-up question also, so that we answer both at What additional skills courses a day should I pursue to improve my chances of getting a job? So I think that's the main thing. Like she wants to know the job prospects with a combination of life sciences degree and patent agent. And
So, yeah, no, I think great question. And I think each one of us who do a degree or a course always have this mind that what additional. So I think in law, it's a continuous learning. So of course, you'll have to continuously learn on this. Now you mentioned life sciences background and you're applying to do patent agent certification. Again, it's a great combination because uh, this area also is evolving, right? If you see, there is a lot of innovation happening in this space, and there's always a intersection of AI with everything. So this is also a very dynamic field, and having patent agent certification gives you a chance to play a role in the IP field. Again, as I said, once you get this certification, that's a starting point, right? From there onwards, you'll have to make choices on what do you want to play, where do you want to play a role with, right? Uh, do you want to play in the litigation space, or you want to work in the prosecution space, or valuation and things like that, right? So that will start giving you some direction on what kind of courses you should take, right? Now, um, I personally feel that for an IP professional, along with certification, law is a great combination, because then it gives you a full spectrum of legal side of it, and your tech background, which is life sciences, gives you a good mix of uh, playing a role in a vast area of domain. But LLB requires 3 years, right? And you should have a liking towards the law. If you don't have that preference, then you can look at either the economics side of it, which gives you understanding on mixing your knowledge of life sciences with economics, and then you can play a role in terms of how the IP in this space can be evaluated, and many things around it, right? You could also choose to do marketing part of it, MBA and marketing part of it, wherein you can then work towards the commercialization part of IP and say how it is. Then you can probably combine it with some of the MBA related courses and certifications and things like that. I would say once you get in one of these, like once you get patent name certificate, try to get into a job or a work role. Try to experience the space, and then you will probably get more ideas on what is your interest and how you should basically grow in that space. um, One advice I would give is that there is no one size fits all in this space, right? Unlike in engineering, wherein you know that, or at least until now, before AI came, you knew that okay, if you do computer science and engineering, you'll get X type of role. You don't have to think too much, follow the crowd. IP professional or IP profession is not that, and therefore you will never have two people follow same path by and large. Of course, the fraternity is small, and the space is niche, so that's the characteristic of the space. But you will have to continuously bring in a combination that is unique to you and your preferences and liking. And what I've seen is people who have done it this way have really excelled well. I've seen people who have combined IP and economics, and they have become like great go-to persons in terms of economic studying consultancy policy papers around economic impact of so and so and things like that. I've seen a career in which a person has become litigator with a good knowledge of subject matter, and has really excelled well. There's a person who has become a tech transfer person and has performed really well. So if you here the concept of enjoying your work becomes very, very important. Just don't follow what others are doing, right? Uh, there's a great opportunity to bring a unique role for you, and I can say that that's how I have followed, and I can tell you it takes time, it needs patience and perseverance, but uh, I really enjoy my work, right? And there was a time when I was trying to transition into IP role from a proven engineering role. I was advised by a lot many experienced people on not doing that transition because, hey, one, there is uncertain path. In engineering role, I had like 150, 200 people working for me, but in IP professional role, it might be more like a very important strategic role, but you may not have too many people working for you. You might have to deal with uncertainties and things like that. But I must say this has been very rewarding. And now people come and say, "How did how can we become this?" Right? And again, my advice is the same, right? No two career paths will be same, unlike in engineering and others, right? Here you have to chart your own path, so you have to be ready for it. And the most important person that will help you in this journey is you yourself, because you will then have to be motivated enough to continue in this journey and enjoy the technology, enjoy the law part, and the aspects around it. And I really enjoy working with startups and all that. I mean, or academic institutes, right? Sometimes I just, and it's not about money or whatever, right? It's just about enjoying the process and helping the ecosystem build the next technology innovation and all that. So if you enjoy this, success will follow. I think. So don't I mean continuously look at what you like. Start exploring. Do not wait too long. Take one certification, let's say patent agent. You have your degree, you have patent agent certification. While you look for other certifications, try to get into the field, gain experience. From there, you'll get some directions. And of course, we can always chat offline also about specifics. But that would be my suggestion.
All right. So I'll announce it to the audience. We'll take last couple of questions. So please, now is the time if you want, if you have a question. Okay, Chichi, I think this question is already answered. You probably need to go back to a certain point in the stream. So yeah, let's see. Okay, there are some questions. With the buzz of AI, Rasisata is asking, will it have an impact on IP careers? It's an important question, probably.
I think certainly. I think there is no profession on which AI will have no impact, right? Yes, certainly. As with every profession, I think there is no denying the fact that IP professionals will have to reinvent themselves, will have to up their game and bring more value proposition than what they've been providing until now. Having said that, where the AI is today, I think it's a great tool. I see that recently Patent Office has announced the guidelines on how they want to use AI for examining the patent application, and that has improved the quality. I would certainly be happy to use that AI as a tool for my work and bring an equal amount of competence in a shorter time and improve my efficiency in that. So yes, certainly I see it as a great opportunity. It is bringing in a lot more challenges in terms of various challenges. I mean, in terms of explosion of prior art, which has generated by AI, it has its own challenges. Should it be considered prior art or not? How do you deal with inventions or inventorship? That's a big challenge. So I just highlighted a couple of challenges, but there are I can list 10 challenges that AI is bringing on not just the IP professional, but IP law itself, policy itself, all the aspects of it, right? But But that's not just unique to IP professional. I mean, doctors are struggling and trying to figure out what their role will be in the AI world. Lawyers are struggling to figure that out. Educators are struggling. So, yes, there will be an impact. But, if you make it your friend and grow with it, you'll probably do much better.
Wow. Great. Thank you. Well, let's take maybe quickly a couple of questions since there is some time. And what is the eligibility for IP analyst? Sri SHR.
Well, I guess there is, again, IP analyst, probably I would say subject area understanding is probably the minimal thing. Let's say if you want to do a analysis, the IP analyst again is a wide role, right? So it depends on what type of analysis you're talking about. But if you're talking about portfolio analysis, freedom to operate, you need to understand the technology landscape, right? That's number one. So generally, I've seen if you're doing that kind of role, you need a science degree or you need a background in that space, right? So if I'm doing a IP landscape or a freedom to operate analysis in automobile sector, then I need to know that space. But you don't really need certifications like patent agent or LLB, etc., to do this. So if you have basic degree and experience in that space, you'll probably be eligible. I think from that point of view, IP analyst role probably offers you minimum barrier to entry, but then it's all your skills in terms of how well you perform in that space and bring your intelligence into it. So.
All right. How a faculty could take up this task? I think what he means is that is it relevant for faculty to invest some time in becoming a patent agent, for example?
Well, again, it all depends on what you want to do with this. Certainly, if you're a faculty member in technology space or in focusing on R&D, patent agent certification gives you a very good foundation and understanding of how you can protect your IP using patents, etc., and then opens up door for you to play a role in your creating a technology transfer office in your institute or R&D company, etc. So yes, it opens up a door. So there's no harm. I always followed this that knowledge doesn't go waste, and these things can come handy when you need it. So if you can afford to spend time and energy into something useful, then this can be definitely useful.
Even for filing more patents.
Yeah. Again, it depends on. See, again. I know people, at least a couple of people I know who have got the certification but have not used it and are doing other jobs. Likewise, there are lawyers who have done a lot of people who have done LLB but have not, ventured into practicing law. So it all depends on how you want to use it. Again, it's a tool. It's a means, and you have to decide what you want to achieve, and it could be a great tool for you or a great thing for you. Yeah. But as a faculty member, yeah, it looks like it's a great. It may help you in R&D efforts and protecting IP and build a good IP strategy or a commercialization is it for you at some point. But again, remember, certification is only the first step. How you use it and build your expertise using that will determine the outcome of it.
All right. Another question. Thoughts on IP or patent? I mean, he's saying that this field is pretty narrow. As we see in the last 20 years, it's a very saturated domain. Very less people know about IP in our country. So what's the question? Is it like a...
Let me give a general broader, we started with that. So I think you're right. This space has been narrow and not very attractive until recently. That's primarily because, in my opinion, we did not have a encouraging ecosystem for IP protection. For whatever reasons, right or wrong, we'll not get into that. But now what has changed is, especially in the technology and innovation, in the technology ICT sector and all that, people are viewing innovation and IP in a very positive way, right? And it has been proven that this is a mechanism which has helped a lot of countries grow in a very fast pace and become leaders in certain space. So without getting into more details, I would say as long as there is a aspiration to become technology leaders, this is a very important tool for that, right? Patenting an IP system, right? Overall IP system is very important to promote innovation, right? There is no question about it, and there's enough studies, economic studies, etc., and all this. And we have seen that journey that India has taken since 2005 as the first step, and 2016 onwards as the second step. I think there is a lot more appreciation of IP as we've seen in the last thing. When I joined this space, it was like a negative thing, right? People will see IP as a negative thing. But now I see a remarkable change in that, and there's a lot many people talking about IP. Even when we look at startups and when we are with investors and all, there is much more appreciation of IP among the investor community and all that. So it'll take time. This is a cultural change and all that, which will happen. But I'm pretty confident, and I have invested heavily in this space, in that belief that this is going to be a great career space, and therefore I personally feel it's a great area and it's continued to grow. But you have to be patient, and you have to be consistent and continue to explore the areas that you like and build on it, so that you're basically are successful in this space. And there are adjacent areas, right? You have AI coming up, you have DPDP Act, which is there. Technology is becoming pervasive. So as a technology expert and a legal expert in technology, you could actually go into adjacent areas with your skill set, and the possibilities are huge, actually, huge possibilities. It's just a matter of sticking to it, continuously working towards your strengths, and then building a path around that. So it's not a profession which will give you a well-trodden path. It's not like a lawyer. Okay, I become a lawyer, I become a litigator and all this, right? Or I'm doing MBBS, I become doctor, I do specialization, or I'm an engineer, I do this. It is not that path. This is the path. If you're an explorer and if you want to do certain things, this area offers you a great combination of technology, legal concepts, and business aspects, and you can play around with it. Of course, there are adjacent areas that also you can build in and bring in. So there's a lot more to play with it. But it's for the people who are more experimental in nature, more risk takers, and enjoy technology and law. I think if you do that, then you'll really do wonderful in this space. But if you're just looking for a straight path, hey, tell me this and I should get X amount of money, or hey, this job or that job, then I think this is a little risky for you in that case, right? Nothing is right and wrong. I mean, it's just about what you feel more comfortable with, right? I'm not saying going for a predetermined path is wrong. No, it's not wrong. It's a great path, but if you choose this path, then you should be ready for this, and then rewards will be different. Because I have lots of my colleagues who are doing great engineering work, but they really love what I do. So it's just a matter of choice, right? And there was a time when I felt like, okay, is this really gonna take off or not? But thankfully it did. So you need to stay put and do it, right? So
yeah. Great concluding remarks. Honestly, this sums up the session really nicely, the things that you mentioned towards the end. And I think it also answers some of the couple of questions I see now that have just come in, but we'll not take it right now to respect the time. And also some questions you can just carry forward to the next session. I can see some questions on section 3K. So please, please ask it in the next session. So great, Nitin. I really want to thank you for your time. It's really valuable. Just 1 hour of your time. I think it helps a lot of people. To how they should think, and if anything, motivates them to something. So great. Thanks a lot. Really, really appreciate to have you.
Thank you again for this opportunity, Rahul. It's always a pleasure to talk to young folks and at least share the about this profession and what this brings on the table. And I think it's a unique opportunity to build a great innovation ecosystem and culture in the country. And all the best for your exam. And if you still have questions, I'll be happy to answer them through Rahul. Please reach out to him and all the
Yeah.
best.
Thanks a
I'll sign
lot.
off then, Rahul.
Yeah. See you. Thank you so much.
Thank
Yeah.
you.
Bye
Have a
bye.
great
All right, all right. So as we wait for Dr. Prachi Pandey, I have a few things I can share with you, a few links. So this event, as you know, is sponsored by the L2Pro India or Learn to Protect India platform, which is developed by Qualcomm, and it is developed with partners like DPIIT, National Law University Delhi. So you can do 11 courses on IP in that platform. It's completely free of charge, and you get a really nice certificate from Qualcomm, DPIIT, and NLU Delhi. And though some of the courses are really really good, I mean, they are not available elsewhere, like technology commercialization, licensing, standard essential patents, patent filing. So please feel free to check out l2proindia.com. It's also a link in the description of this video. You can check it out, you can sign up. And it's a great introduction to the field of IP and some of the things that Nitin mentioned. And one of the good things I like, about L2Pro India is that it associates IP with doing business, associates IP with startups as a tool for startups to use. So that is the name, also the name of the platform. L2Pro is Learn to Protect India. So please check it out in the description. Uh, it's a free platform. And the second thing I would mention to you, it's also a link in the description. So recently, I created a course on deep tech entrepreneurship. It's created in association with Qualcomm. It's also free of charge, and it is hosted on our platform. It's also in the L2 Pro India platform, that same course. And in the deep tech entrepreneurship course, it's an entrepreneurship course, but with a strong focus on intellectual property rights. So at every stage of the startup, you have a certain different IP strategy. Like sometimes you need to do patent filing, sometimes you need to do a trademark search, sometimes you need to do a freedom to operate search or a patent landscape search. So there are many different situations a startup will present to you, a real business will present to you, and all those situations have a different IPR strategy. So that is the unique characteristic of that course. It's an entrepreneurship course, but with a strong focus on intellectual property rights. So again, that's also a course that is free of charge. Please feel free to check it out from the link in description. And now we have with us Dr. Prachi Pandey. So I will welcome her on the stage. So Dr. Prachi Pandey, she has been associated with Turnip for over 6 years. She has taken countless expert webinars on patents. So she is one of the leading academician in patent law. She's a registered patent agent and also a registered trademark agent. So if any trademark agent aspirants are there, you can ask her some questions. She has a PG diploma in IPR from Nalsar University, Hyderabad, and she is in the field for almost 20 years. So really, happy to welcome Dr. Prachi Pandey on stage. Thank you so much, ma'am. Really appreciate having you again. And yeah, the session is yours.
Thank you so much, Dr. Rahul Kapoor, for the kind introduction. And a very good evening to the innovators of India. Uh, I think a lot of academicians, entrepreneurs, startups, and even the student innovators are present here. So I would like to congratulate you for joining this webinar because you might be thinking of making IP as your career. And I wish to let you know that intellectual property is such an important tool for all the startups, all the innovators, that once you create something due to your hard work, your efforts, your initiatives, it must be protected. Whether the creation be a product, a process, whether it's a literary work, whether it is a code, source code, object code, or whether it is a trademark or any literary things, it's better to protect, because once you protect something, you go for commercialization, monetization, then it's really useful, and then you can get the fruits of your all hard work and innovations. So nowadays the era is the era of startup. The GDP of the country is somewhere significantly affected by the startups and the indigenously produced goods, but the monopoly is important. Whenever you monetize your innovation and by converting into patent and then further by IP commercialization, IP licensing, it's become a asset for every innovator. And who helps in this? The patent agents, patent attorneys, IPR professionals really help the innovators and startups to have their patents monetized, commercialized. Many times academicians and students ask me whenever I have a patent granted, because I have helped many academicians to have their granted patents in their hands. They become very happy with the certificates. But my further question to them: what will you do of this certificate? Normally, with before the expiry of 3 years, you should have done something significant work out of this patent. Significant means you must have produced in enough quantity in India. You must have given some employment to the people of India, and it must be indigenously made in India. That's why Government of India has given you the patent rights. So it's your duty, it's your honor to actually monetize your patent assets. But how to do it, how to actually get it granted, how to make the agreements, how to do the IP licensing, all these are actually you can say that patent agents and attorneys are legally expert people of all this, whether to get a patent granted, because even a published patent doesn't have much value unless until you get it granted. And you have a monopoly of marketing and exporting, doing, making, selling everything for a period of 20 years from the date of filing. So today, as we all are here and we aspire to become somewhere patent agents, attorneys, IPR professionals to help the startups, or some, I think, many of you might be academicians, faculty members who would like to have the knowledge of patents, because it will help you in your academic journey. It will help you in get your patents granted. You can directly go for your like grant and reply to first examination report directly. So the knowledge is must. Knowledge never go in vain, and it's important to gather that knowledge. That IPR, whether you make IPR as career or do not, but it's important to get the knowledge, get to like even clear the patent exam. You can get your patent prosecuted by yourself only. I always say innovators be equipped with knowledge of patent prosecution, reply to the first examination report, agreements, then your licensing agreements, documents. The laws are very important to be known by everybody, and that's why we are here today to learn exactly how to make IP as a career. And also beside your normal jobs, normal profession, you should have IP as a weapon to fight against infringements, to protect your innovations, and to further commercialize. So I would be happy to answer your questions. I would be very happy to interact with all of you. So whenever you feel to ask something, you can definitely put your questions in the comment box, and we will definitely interacting with you. So today we are here for IPR Career Summit, and for that I'm just focusing on, first of all, why to make IP as a career in India. So innovation is must. Whenever you add any technical advancement in the already existing invention, it becomes innovation. There are a lot of technical gaps are present in the already existing innovations that you need to find out. You need to frame your problem statement well, do a very extensive patent search, find out the loops, find out the loopholes, find out the gaps, try to fill the gaps, and make something novel. Make something very useful. It should be not obvious, and it should be away from the statutory limitations such as Section 3. So once you are very clear about your innovations, then you definitely have an impactful innovations, and nobody can stop you from getting it granted, because if you are technically strong and you have a legal knowledge and expertise, definitely you can help others, you can help yourself in having your patent. So every patent aspirant, every student innovator must see the future related to intellectual property. The future is quite bright, because unless until you have a monopoly in India, you have a monopoly in other country, you cannot capture the market. You cannot actually get the actual benefits, actual monetary benefits out of your innovations. So why IP matters now more than ever? It is said that earlier also IP was very important, but nowadays why it is so much important? Because there is a record-breaking filing of IP in 2024-25. India's intellectual property ecosystem is enhancing by thresholds. There is a breakout moment. Total IPR applications surged from 19.75 to, you can say, so much, 7,49,946 in financial year 2024-25. That was earlier less. It was about 63,55,000 in the previous year. So this is the IPR application that is all along the world. It has a breakthrough enhancements in the patent filing. So we can see the world is running behind filing the patents, prosecuting the patents, having the patent grants. What is the reason? The reason is the innovation. Innovation is growing by leaps and bounds, and if somebody is not protecting it, all of the innovators might enter the market simultaneously, and I think nobody can generate so much revenue out of their hard work. Indian citizens are not lagging behind. Patent filing by Indian citizens jumped 32% in financial year 2025. Now it is 68,176 applications by India. That is tripled in just 5 years. In year 2021, it was 24,326. It is just, you can see, now it is 68,176 in 2025. So we can say that it is a jump to 32% of increase in just 5 years. Is not because we have a lot of like patent attorneys and agents. It is because of there are a lot of innovators, and now every innovator has awareness that they should protect their important innovations, and they should have a patent granted, they should commercialize it. Even if they can't run their own company, why not to approach other companies, can sell your patent, can commercialize and earn lots of revenue out of that. So I say students, faculty members, even some of the startups who have a very good innovations, you run your company. If you have more patents, go for IP commercialization. It's a great source of revenue, not only in India, but why not to go abroad? Why not to sell them abroad also, and also get it licensed and generates lots of revenue. India, now I'm talking about India. India has a fourth global ranking in patent filing as of 2023. And as all the innovations are very important for startups, for startup economy, 100 plus startups are normally IP focused startups are driving the innovation across all sectors. There is a rising demand for IP professionals because it is needed. It is the need of ours to have the IP knowledge. Without IP knowledge, you can have your trade secret formula, but How long? It is not the way actually to monetize it. Everybody must have the right for 20 years for generating a good revenue, for making a brand for long, so that people must know the brand. If a lot of like consumer products, lot of products are directly entering in market, they cannot make their reputation. So especially in pharma, manufacturing, deep tech, and even for softwares, because there is a new CRI guideline launched in last year in August. Even the software coders, they have the chance of having their patents. So it's a very encouraging silver line we can see in the near future for patent professionals. And you can say that even for trademark, because trademarks are, you can say that it's a boon for startups, the new startups who can launch their own products with their own branding, reputation, recognition. Even India ranks fourth in the form of trademark applications. Generative AI patents, now this is becoming also very popular nowadays, because software patents have also taken a very important place. So India ranked globally fifth in terms of generative AI patents. They are just lagging behind China, US, South Korea, and Japan. So AI patents, because even in healthcare, digital healthcare, agri-tech, even they use the AI, ML algorithm. So once you acquire the knowledge of patents, acquire the knowledge of all IPR, it can become helpful for startups also, and can for you also. But to know how exactly choose IPR as a career, somebody asked me, I should have a very good English, I should have a very good scientific background. Definitely, scientific background is important, but for particular domain, legal knowledge is somewhere important. But important is your skill, your interest, and how critically you see a paragraph so that you can draft a patent application. Should have a very critical view on find out the important innovations that is hidden behind a long paragraph. That is a patent agent exam actually find out in you, that how critically you see an invention, how you can find out what is important, what could be patented, and what sets them apart from the already existing innovations. Sometimes things look very similar, but some important incremental innovations can add some value to the innovation and can capture the market for years even, because even a small solution can bring it. So while drafting a patent application, I always suggest the aspirants like do not have a bird eye view. Go very critically and see what makes the innovation very different from already existing ones. Even a very small one, even if it is very user friendly, very affordable, even a small part is making it very different. So in that way, you can acquire that patent. Technical tools is important, because it should be a science graduate. If you are a LLB, you can definitely become patent attorney also. But for becoming patent agent, the graduation in science is important, and you should clear the exam of patent agent exam that is very near. Normally, it is conducted in January. So date have been announced, and you can fill the form state. I think it will be lapsing in September. So by the time, you should prepare yourself for filling the form at least, so that you should be able to, you should have about 3-4 months to prepare for the exams. And you have to see the basic, the sections, subsections, and drafting. Normally the first paper that has a section, subsection, and rules is you can command over it by reading it through like a story, how the things goes one by one. In drafting part, again, I'm just suggesting that you should have a very critical view on drafting, because many a times patent agent exam become difficult for paper 2. So draft patent applications, filing applications, responding to examination report, representing clients before the patent office, this is not a very easy task. But once you acquire the knowledge, once you clear the exam, and once you start practicing, it can become a boon for the startups, for the innovators. Could be very helpful for them. Key advantage is that if you have a science background, if you have a like engineering background, you can definitely have a large area to cater on. Trademark agents also, I'm just covering a little bit. We need a university degree. We should clear the trademark agent exam, or any advocate or ICSI member can become the trademark agent. Trademark has a wide field because all the companies must have their word mark, shape marks, their branding, their recognition, their differentiation in market, because they have to capture the market. Marketing is very important nowadays. You just open any Amazon site, any Flipkart site, and you can see even the small facial cream has n number of brands. Why to choose this? Why to discard this? Why not to consider? Why to consider? So it all depends on how you present it and how you own a brand, how you own a reputation out of yourself. Copyright and design specialist, once you know, design registration is also very much important, and now it is in the patent agent exam also. So design act tells us about whenever something is aesthetic, and it could be protected in the form of its shape, its looks, without its fundamental character, without its functional features, then that design could be registered. It has definitely an importance along with the patent, because that design makes you a very demarcated from other products in market. You can even sell your design like it looks like this, and because of certain design, people would prefer to take up that. So and copyright normally we do for literary works, software works, algorithms. But once you use the software or algorithm to make a product that is a tangible product, a hardware that could be used, then that that could be liable for a patent. So why not to copyright your algorithm, copyright your software, copyright your code, later use it to convert it into a product. The product is highly patentable because it uses a deep technology, digital technology, and go for copyright, go for patent, and then further have own a brand, design go for industrial design registration for the shape, size, or aesthetic appearance of your product, and further go for the trademark of the shape, trademark of the word. So all the four means copyright, design, patent, trademark, all could be owned by you only, and that will generate definitely a lot of revenues, and you can help others also. Whenever the patent agent, copyright or design specialist or patent agents become, they can work directly for pharma companies, tech companies, FMCG sectors, startups. They can manage the IP strategy, they can help in licensing, they can make the documents for companies, they can help in enforcement and commercialization of patents. They can even talk to companies in terms of a proper agreement making, so that startup must not suffer, they should get the right royalty. So normally IP councils have a very high stability in terms of job protection. They have a very competitive salaries, and they have a direct business impact. So I agree that still jobs are important, but nowadays this is an era of startup, entrepreneurs, innovators. So they all need the support of the IP council. And this is the field now, actually, this is a field not saturated. This is a field being opened since last 2016 after startup policy and IP policy. So in this field, I can say that entry to mid-level career earning is really good. 6.5 lakh entry level, up to mid level you can earn up to 13 lakhs. Senior or partners of a legal firm can have 40 lakh per annum. So such kind of satisfactory salary you have. Beside that, you should have a freelancing, like you can go for freelancing at any level, and your earnings doesn't have any boundaries, that you can earn a lot by your own innovations, by supporting others too. So education is important for becoming a IP counsel or patent agent, patent attorney. You should have a graduation degree. If you are interested in law much, you can even go for LLB. You can become patent attorneys. You can get some internships or trainings also from like even the patent offices or IP firms are now providing these facilities. Or you can specialize. You can become patent agent. You can become trademark agent, but there are separate exams for patent and trademark. IP career paths in India, because I have cleared patent agent exam as well as trademark, both have a different kind of syllabus, and both are patent is linked more towards the innovation, the product. where trademark is more towards the startups, their brands, and both have different section and laws and rules. Design is a small area, that's why it is being covered in the patent agent exam itself. And you should remember some sections, rules of the Design Act also. So IP career paths are patent agent, where they represent the client before the patent office. This is a respectable position because you have a knowledge of laws that even the patent examiner consider it very well. You are able to draft the applications, file it, prosecute it, and get it granted. Also, even you can help in IP commercialization later on after the grant. uh, Patent agents have a good knowledge of IP infringements, so definitely they can help in the IP infringement cases also. IP attorneys, because of their specialized knowledge on LLB and legal grounds, they provide legal counsel on IP disputes, licensing negotiations, strategic portfolio management, all this. IP consultant is an open field. You can even participate for IP audits of companies. Valuation, IP valuation is important, especially for startups. IP valuation is, there are several methods that is to be known. Commercialization strategies, that is also a field that is of IP professionals. And this is I think I always say the patent aspirants do not just consider it as a patent agent or attorneys. IP consultant is a wide field where actually the mining, valuation, commercialization strategies all become a part of the IP professional, and that is actually very lucrative job for everybody, but it needs lot of persistence, hard work, and you must have a very devotion up for your profession. So everybody has it. So and another option is patent examiner. So evaluate the patent applications on behalf of the patent office. That is a government career in IP. Normally advertisements come, and you can appear for that, but basically this is a totally technical position where examinations are also technical. Who is a patent agent now? So, patent agent is a qualified professional, we all know, which is registered under Patent Act 1970. They are authorized to practice before Indian Patent Office. Nobody else than patent agent can practice before Indian Patent Office. Nobody else, means like a direct graduate person or anybody cannot. It's illegal. So a patent agent draft the patent application. They write complete or provisional patent specifications. They file, prosecute the patent applications, respond to first examination reports, make it. They represent the client in hearing. Actually, they have a technical as well as legal background. They're the best person to represent your innovation before the patent office, because they can take the help of sections. They can tell about all the formal requirements. They can even intervene in the all the statutory section 3, whether your invention, suppose it falls in section 3 or section 3D or 3E, normally very common. Patent agent can really have a rescue for them. So they can surpass it by like pleading over it, like lot many cases have been done in the past in which it is done, how like it is becoming little different from the section 3D or 3E, means they have the expertise of that, and that expertise you gain. That's why you all are here, to learn about it. So what is the eligibility requirement? First of all, Indian citizen should apply. Age minimum 21 years of age at the time of application. So after graduation, you can apply. Degree in science, engineering, or technology from a recognized Indian university as mandated under the Patent Act. And equivalent qualification may be recognized at the discretion of the central government, but it is case to case basis. Basically, these three are the eligibility requirements: citizenship, age, and education. Now, the point come the routes, how you can become a patent agent. So, first of all, you have to, there are two routes actually. Either you can clear the patent agent exam and pass exam. Another is if somebody has served for 10 years, more than 10 years as patent examiner, they can become the patent agent. Another is patent controller experience. If somebody has a patent controller experience with more than 10 years, they can directly become the patent agent. So these three ways are there, but you can just imagine like how important is to clear the patent agent exam. It is treating being equivalent to the experience of a patent controller, patent examiner. So clearing the exam is really worth, and studying patent act is even more worth, because the knowledge will always help you out. uh, the exam structure is paper 1, paper 2, and viva. So now about paper 1. Paper 1 is about laws and rules. It incorporates Patent Act and Rule 1970 with all amendments. Amendments are really important because in every amendment, 2005 amendment was very important, in which the product patent was introduced, section 3D was introduced, all TRIPS agreements have been incorporated. So basically legal framework, all kind of even the assignment, applicants, substitution of applicants, every small things are given in the Patent Act and Rule. These are important ones. Working of patent, your compulsory license, like from starting from section 84 to 92, you can say these are very important sections that you need to study, but it needs your attention and interest. If somebody is interested, it's nothing like I can say it's nowhere difficult. You can definitely crack the exam, but you should be very interested. You should have at least 2-3 months of time to prepare for it, and you should meticulously go through the act and rules. That is there are several sessions I had conducted also in the past, in which I had explained it in a very simple way, exactly how to crack the exam, how to study the act and rules in the form of a story, so that all things are linked actually. One by one, all sections are linked, and it becomes like a story, like how it applicants, what are the applicants, what are the patent like forms, how it works, how to be filed, how to be prosecuted, how to surpass the infringement. All these are just like one by one linked to each other, but you need to study, uh, I think, with interest. And I have simplified it actually in some of my earlier lectures. I have made it very simple, very interesting to understand with the help of examples. So yes, interest is must. Paper 2 is drafting. Again, I tell you one more important thing. Drafting is done only when we understand. Whenever you get the paper 2 of patent agent exam, I always say students to bifurcate your timings. If the exam time is suppose 1 hour, you devote at least 25 minutes to read the patent, the paragraph. You read it out, and not only read it out, because our memory cannot store everything at once. Read it out, have a rough paper, even the back side of your answer sheet, and try to write something very means like crucial that you found or noticed while reading it. Just find it out and write it, like which component you found it's looking little bit more innovative, or it can add some innovations. Just map it out, list it out, write out the process through which it is working. If you feel that it's a novel process, definitely you should note it down. While having, suppose if it's given a machine or something, just see it critically, how it looks different from other things, and how some small even a small mesh, a small screw, a small kind of attachment can make it different from other innovations. You should notice that. And output, how output is given, because in every question normally examiners want you to find out the best output so that you can draft your claims. So map it out in rough. Do it for 20-25 minutes. Relax. Time will never go anywhere. And then draft a rough claim, like what could be the best innovative components, but do not list it out. Your claim must link each component in such a way that it should look like a unit invention. Like this, suppose a laptop is there, it is consisting of several things. So it's not just a assembly of components, it's a kind of working in coherence with each other so that the final product becomes innovative. So write in that way, link each component with each other, support each component with each other, and finally at the last, write the output out of this. And that output must be improvement. So claim drafting is important, but everywhere claim, whenever you write the claim syntax, syntax, you can read how to join all this claim and make it. Important is that your Jepson claim is very important. Improvement claim, you should must write wherein the improvement lies in, and that improvement you must notice while reading the patent application. So make it a unit invention. In that way you can surpass the like section 3 is like it's not an assembly of devices. Make it supporting to each other so that it's not just a listed one. Make it non-obvious by making it a little bit more innovative in terms of its components, its assembly, its process, and its final output. So just keep in mind that you have to cross the nonce test, you have to cross the section 3, and just keeping all those things in mind, just make a claim out of whatever you have noticed while reading your patent paragraph. So, in this way, actually, your examiner will find that you have meticulously read the application and jotted down in the form of a claim. So patent drafting paper 2, you can easily get it cleared. Normally students say me that I am just lagging by 1 marks or 2 marks. I say them, why not to aspire for even full marks? Why you are lagging behind 1 or 2? Because your effort was even 30-40% less. So you should be very focused while reading the patent application. Forget everything. And viva then again become a point where you have to be very impromptu, very spontaneous in answering. Your patent examiner want that you should have the answers of questions, not even if you remember the laws and section, at least you should tell the technical part. Sometimes people think that I should always say with reference to laws and section, rule, subsection. It's okay, but if you don't remember, don't skip the question. Never become nervous out of any question. uh, First listen to the controllers, because some controllers, some examiner will be sitting there and they will be asking you in a very detailed way. First listen to them, just give respect to their question. Do not start answering in between. Totally listen, understand. If you have some queries, do not answer, you can ask them again. And try to answer with respect to logic that is behind that section or rules. In between you can quote the section and rule if you remember, but try to speak more, try to elaborate more. Do not just think that these are controller or examiners, they might be knowing. No, you have to speak whatever you know about it, in a very simple way. Do not make jumbled sentences. Do not think that it's a law, so you have to speak about long sentences, jumbling with all those. Try to become very clear. Clarity is the rule of clearing the viva voce. You should have the understanding, so you can make them understand. You should ready to answer. And important is the recent amendments, some recent case studies. They would always like that while answering, you should quote some example that will add really an ornament to your answer. That is the quick. I have also one session on viva voce, and very soon I think we will launch one more session on viva that is important for you, how to clear the viva. So overall understanding, communication, and readiness, but always try to be very simple, very humble, and just oriented to the answer, nothing else. So that can help you to clear the viva. Passing criteria. Clearing the patent agent exam require meeting both individual paper thresholds, means minimum 50% marks in paper 1 and paper 2, and overall aggregate of 60% across all components. So passing marks is important, but not just passing. You should score little more so that you should have an overall 60% aggregate of the total marks. Exam is conducted annually nowadays. So if you are missing even by 1 mark in any one paper, you would be disqualified. So important is first to score the minimum marks. So whenever you have a paper, so do not waste much time in just one question who is of 2 marks. Just in paper 1 especially I'm telling you, because you should have a like aim of covering the whole question paper, And you can give some more marks if the question is of 4 marks, but for 2 marks question, 1 mark question, try to be little fast, because your final marks at least must reach 50, and you should have at least 10 minutes left in paper 1 to revise and go back. So I always say in paper 2, don't go back, give more time in the first 25 minutes to read, because there is no point going back and correcting your claims. But in paper 1, always you should go back. So keep 10-15 minutes in extra with you, so that you can again revise. You can even if you have not marked, then you can even change your answer, and you can at least score the 50 marks. So, and some questions you can really have your common sense, you can apply and answer it without relying much on your memory. But sections must be remembered. But again, I said you that remembrance is always based on interest and inquisitiveness, how you can, you are curious to know, and how you can apply your knowledge in answering. Navigating the syllabus, we have the Indian Patent Act and rules. So Indian Patent Act 1970, Patent Rules 2003 with latest amendment. I'm again emphasizing on amendments, because amendments are important. Very important decisions are there in amendments. So you should have a separate time frame for preparing for amendments. Patent drafting is important for paper 2, especially for claims. But claim you can draft well, because you know the syntax, everybody is practicing syntax. But drafting the claim means that you should cover all the components that are important, all the outputs that are important. And IPR fundamental and ethics, overview of IP right is there. Once you clear the patent agent examination, paper 1, paper 2 and viva, I always say best wishes to all my aspirants, you have to file the form 22. You have to register yourself as patent agent with supporting documents and pay a registration fee of 3,200 plus annual continuation fee of 800 per year. That is mandatory to become a registered patent agent after clearing the exam. What are documents required for registration? So you have to submit the form 22 with date of birth proof, passport, PAN, voter ID or birth certificate, citizen proof. Your passport will work very well, voter ID, degree certificate, science, engineering or technology, and character certificate that is issued by a gazetted officer, or disability certificate if applicable. The point comes about what should be the skill for IP success. Many times some people become patent agent, but still they should must develop the core skill of practicing the patent agent. So once you clear the exam, it's proven that you have the knowledge, you have the skill, but you must have a deep understanding of your science or engineering field also, so that you can evaluate the patent application, you can draft the invention. And usually you see that the patent agents of their domain have the knowledge of that domain. So in that domain, you can definitely excel. IP law fluency is important. If means like not all section and rules can be a part of your memory. That's out of means like it's sometimes not possible for everybody. But you should have the knowledge exactly where the applications of section and rules may be there. So if applications are known, later on you should have can refer the law books and can quote the patent section and acts, subsections, rules, everything. I'm just telling you about the practical aspects. International IP frameworks must be known to you. PCT filing must be known to you, because even the PCT filing is being asked in viva or patent agent exam. It's an Indian Patent Act, but they expect that you must be able to file the patent worldwide. Then only you can generate a lot of revenue for you and your startup, your companies. So international IP framework, PCT filing, Paris conventions, TRIPS agreement, everything. And even you should know the patent search worldwide, WIPO, everything, you should have the full knowledge of that. Patent drafting precision is important. It's a very precise way where a legally sound patent specification is made. Claims are drafted. That is, a clarity is needed. You shouldn't have a very jumbling patent claim. It should have a very clear patent claim. Yes, coverage is important, You should cover a big area in the range, but important is also the best mode. The best mode, because many time objections are about when you are dwelling over a large range, what is your best mode of application? That is also important, that your optimized process must be highlighted there for having a clear patent right. But whenever you feel that there's a lot of efforts in even finalizing the range, you should go for the range and you should justify that I have done lot of experimental studies out of this range. I have tried and tested, and then I have these foundings for the whole range of data. Suppose if you are taking some of the polymer concentration that range from 2% to 10%, it's not just you are saying, because you have tried lot of experimentation ranging from 2, 3, 4, 5, and you have the findings out of all of the ranges. That's why you can definitely quote it and definitely protect it so that nobody can make from 2 to 10. Definitely, but you should have the data, you should have the justification for that. So you will have a large area of coverage, and no other innovator can enter that. If they enter, definitely you can sue them for infringement, and you will have a large market. Communication is important. You should argument effectively with politeness and firmness, both before the patent examiner during hearing and examination proceedings. It should be very clear, one by one, every query that is raised by examiner, whether you see it as very important or not important. Take it significantly and answer it meticulously. Every query, even simple formal requirement, take it up that is being raised in first examination report or hearings and answer it well. Make the hearing submissions. IP opportunity is there because there are a lot of patent applications are being filed. CAGR is like 15%. IP law growth throughout like 2030, it may go up. So the market is by 2030 and beyond, India legal business and business landscape is expanding by leaps and bounds because of the now the GDP of the country is increasing, gross domestic products are being manufactured. Patent is not just a kind of luxury or ornament in some academician's profile. Now it's a need of the hour. It's the need of startup. It's the need of companies. It's the need of makers, innovators. So that's why they also need the patent professionals to help them. So it's better that IP opportunity must be seized by everybody. And now I'm switching over to some questions. If you have any question, you can ask me. I will definitely love to answer them. But if you have any question, otherwise I will switch to some of the patent agent exam questions for you.
Ma'am, your slides were not moving sometimes. So
Okay.
I was moving them, but sometimes it was not in sync.
Okay.
One question is from Anusha. She asked earlier, actually. It was so she has two inventions, both made of same composition, but one is serum form, other is gel form. Should I
Okay.
go with one patent or two individual patents?
Okay, Anusha, thanks for this question. I think you might be a pharmaceutical background innovator, and you have two inventions. One is in serum and another is gel. Okay, first of all, I would like to know something more about it. In serum and gel, is the same components, means like your API is the same? And what is the difference in output between the serum and gel? Important is that. First part is that if it is becoming the same API, controller will have a direct question. It is a very obvious innovation. First question would be this. Now, the next question arises whether gel is better than serum or serum is better than gel, or both are very similar products. One thing could be that ease of application for serum or gel, that can be like differentiate in terms of its innovativeness. Like if your gel is being applied quickly, or it has a deeper penetration inside the skin, or if you have done some of the evaluation studies to actually find out its efficacy. Suppose if it's the antifungal, so the antifungal efficacy you might have done in the microbiology lab, you must have the data. So if your serum and gel are both equally inhibiting the fungal infection or anything, I don't know for which indication you have made, psoriasis, fungal, scalp, or like acne, anything. But if the efficacy is the same, then like first of all, if you file the patent first for serum and then for gel, then serum first will become your prior art, and controller will raise a question that how your gel could be better than serum even for your own invention. First thing is that simultaneously filing, even if it is a seconds different, one would be the prior art for the another. For making it a two different inventions, you should definitely at least one output that is significantly different, whether ease of application, cost, affordability, or efficacy. And definitely you cannot cover both the products in a single patent application, because a patent controller will say you to divide the patent application and file separate patents. You cannot cover two inventions. So you can definitely file two patents, but be sure your API must have certain kind of difference, your excipients must have certain difference, your output must have certain difference, or your ease of application or cost might have certain difference. Then only you can have both the patents. Otherwise, one can become a prior art for another, and you can get the just patent of one if both are almost the same in that case. If you have any other doubt, you can definitely drop a query.
Yeah, please feel free to put the questions in chat. I'll tell the audience. And whenever there's a good question, ma'am, I'll just come into the stream
Yes,
and I
that
can
is
put
a
it.
good one. Actually, gel and that's a good one. Many times people come with two different type of formulations and they wish to patent it. So I always say that while filing the patent, one become the prior art, but you should able to defend. Then only you can have both of them in your name.
Yeah. Yeah, we can continue with the, ma'am, whatever you plan.
Questions.
Whenever
Fine.
there's a question, I'll bring
Thanks.
it up.
Yeah. Thanks, Dr. Rahul Kapoor. I think the inconvenience is not much for the shifting of slide, but okay, I'm shifting it right now only. So the next question is from a patent agent exam. I think this is a very simple question. So under the Indian Patent Act, which one of the following is not patentable? The question comes: a new process for extraction of oil from plants, mathematical method, a new chemical compound with industrial application, and a machine to reduce the carbon emission. So the answer is very simple, as you can see, like new process. Already India has a patent since long for the new process. New chemical compound, it has machine, always tangible products, only the mathematical method under section 3K, where the mathematical methods, algorithms, or business models are not patentable. So such questions normally in section 3 you will get about 2 or 3 questions in patent agent exam. Which of the following grounds is valid for pre-grant opposition under section 25 subsection 1? So first of all, applicant did not disclose a good brand name. Applicant was not born in India. Invention is anticipated by prior publication and invention is granted already. So only the answer is C. Invention is anticipated by prior publication. So what does it mean? Simple, just now for Anusha I answered that serum is filed early than gel. It could become a ground for opposition, because if somebody has filed a patent earlier than you and it is in the public domain and it is anticipated by prior publication, suppose serum is there, it is published, and I have made a gel using that serum formula, serum API, and now applied for patent, so it becomes a ground for pre-grant opposition. The question comes about true and false. Such kind of questions normally come. A complete specification must always be filed within 12 months of provisional specification. That is true. Everybody knows it. Patent application can be filed in India only after foreign filing permission is obtained in all countries. No, actually not. It is Form 3 under Section 8, where we have to inform the patent office that I have not filed any patent in any other country. And if I will file, I will let the patent office know about it. So this is the form normally we file with form 1 and form 2 itself directly, or within 1 month even you can file the form 3. But it is not true that it can be filed in India only after foreign filing, not like that. So the third question comes is the PCT application, that is PCT national phase application in India must be filed within 31 months from the priority date. So this is true only for India. For other countries, what is the timeline? Can I expect some answer in comment box? Can I get some very, very nice, because you all are answering? Yeah.
Yeah.
Divya Raman.
30.
Nice.
Yeah.
30.
Nice.
30. In
So
India
it is
only
quite
it is
fast.
31. Yeah, definitely. Good answer. Okay. Another question. Name any 3 invention not patentable under Section 3 of the Patent Act. Normally, such questions will come in your paper 2 also, in short answers. So you can name any 3 inventions. First is your frivolous, Section 3A. Method of agriculture or horticulture, Section 3H. Computer program per se, Section 3K. Another question normally being used is, what is the difference between pre-grant and post-grant opposition? So what is the basic difference is between the pre-grant and post-grant is like can be filed by any person, and post-grant can be filed by interested person within 12 months of grant. This is important actually. So after publication before grant, any person can file the pre-grant. But post-grant is filed only by interested person within 12 months of grant. Now my question comes to you. If anybody can answer, who is interested person? Who can be the interested person? You can just write in one sentence. And interested person can file the post-grant opposition within 12 months of grant, not after that. So who could be the interested one? And what is difference between any and interested? Yeah, Divya Raman, again, you are on the right track. Knowledge person, particular field. I wish to add something. Interested person means not only knowledge, but working in the field. Suppose one pharma company is there who has a kind of a patent granted, and another pharma company is doing the post grant opposition, then they can be treated as interested person because they are linked with respect to trade, with respect to revenue, with respect to the earnings, because they may feel that the patent is being like infringing their invention. Patent is similar to their own invention that they have already applied, or like they are granted. That's why they have an interest on that. They definitely have knowledge, but their business is being affected, and that's why they are considered to be the interested person. Without a business, without anything, patent office will not entertain your post grant opposition, because the whole process has already completed. Means patent examination is done, reply to examination is done, hearing is done, every answer is given, novelty search is done, anticipation is checked. After that, if somebody's come up, definitely that person is interested because he belongs to the same domain, same business, and that's why his business might suffer. That's why he has applied for post grant opposition, but within 12 months of grant. Form 27. What is Form 27? I very initially told you about the working of patent statement. So whenever you have a patent in your hand for academician, faculty member, normally they become happy, but they do not actually commercialize in terms of production of product in India, giving employment to the people of India, or making it indigenously. What they do is like they just sit with the patent. So before expiry of 3 years, you have to submit a Form 27 to Patent Office with the statement. And if you are failed to do that, then you may be liable for a compulsory license at the terms and conditions of the company itself, who is taking the license from you forcibly. And who is intervening in giving the forcible license? Even the patent office, government of India, because they will say that if you are not making, why not do you give your formula to another company to make it? So another company will make it, but they will take up the formula at their own conditions. That is compulsory license. So I always say people who have a granted patent that try to commercialize it as soon as you have your patent in your hand, so that you can address your own conditions in negotiation with companies. Later on, at the expiry of 3 years, before the 3 months before the expiry of 3 years, whenever you submit the form 27, it will be difficult for you. So form 27 is for working of patent statement. Now the question, the last question, these are some of the questions which are important. Can a patent be restored after it has lapsed for non-payment of renewal fee? If yes, how? So yes, patent has to be kept live. Once you have a patent in your hand, it has to be renewed every year. So first 2 years, it's okay. Before expiry of the first 2 years, you need to start the renewal fee. If you fail to give the renewal fee, it's not much. It's like a 1600 rupees, 800, then 1600, 800 for 4 years, then 1600 for 4 years, then it goes on. So patent can be restored by making a request within 18 months from the date of lapse, if it is lapsed, under section 60, by filling form 15 and by paying the prescribed fee. So patents can be restored many times for academicians especially, or students sometime who are not very careful about whether the patent gets lapsed. It's the guideline that before expiry of 18 months, they should apply for restoration of the patents, and they should give the penalty as well as the prescribed fee for restoring it. So that is possible. Some of the solved questions I would like to take up for you is like a question was an improved solar powered portable charger that has a foldable frame, multiple solar panel, a battery which stores power, USB-C and USB-A output, and a LED light. This is about the drafting. The charge further has an indicator to show battery level, and the frame folds into a compact form for travel. Draft a title, draft a field of invention, draft a background, draft a summary, at least one independent claim and one dependent claim. So this is the question in drafting, and this is not a very 2 or 3 marks question. This could be a 20 marks question. So you have to be a little bit meticulously read it. So what could be the title? Portable solar powered foldable charger with LED light and battery level indicator. Just a minute. Okay. Yeah, the slide is correct. Field of invention, you have to write something about in which field you are working. So present invention relates to, this sentence must be kept. Portable power charging device, more particularly to solar powered portable charger, having foldable panel, multiple output ports, and a battery level indicator. Just define it thoroughly in field of invention. Point come the background. Now the background, as here actually in actual patent applications, you have to cite the already existing claims, already existing patents, and write something about them. And at the last, write how you are different from all of them, and how you are filling the technological gaps, what are the loopholes in the patents, what are the loopholes in earlier prior art, and how you are adding innovative technical advancements over it. You should prove that there must be a human intervention to make it more novel, more non-obvious, but you need to point out. So background is you describe existing charger, issues in charger, what is the limitations, what is the lags, what are the lags, what are the no battery level indicator, emphasize how the prior art is lagging in some of the innovations. Summary of invention, you have to describe the features, all the features in detail. Foldable solar panel, frame for travel, multiple solar panel, integrated battery, USB-C, USB-A, everything, each simple component, screw, nuts, attachments, everything in summary of invention. And at least one independent claim should be drafted. So in independent claim, what it should be. So one drafted claim is with you. So independent claim says what? See here. It says a portable solar powered charger comprising. This is again a open-ended claim where I'm incorporating the components but linked to each other. And also it's not like only these components, it can incorporate more components beside that. So open-ended claim I have kept. A foldable frame supporting a plurality of solar panels. It should be separated by a semicolon. A battery connected to said plurality of solar panel for storing power. Always connect and say the improvement and purpose, which purpose it is connected to. Again, a USB-C output port and a USB-A output port electrically connected to the battery. Means you can see here, all are connected to each other, supporting each other with a purpose. A LED light powered by a battery, and a battery level indicator for displaying the remaining charge, wherein now the point comes about the improvement, the exact output of the product, wherein the foldable frame folds into a compact configuration for transport. So my purpose is to give you a compact configuration for transport. That is my final output. And to support it, these components have been not listed but combined to each other. Dependent claim, one dependent. The portable solar powered charger according to claim 1, wherein the plurality of solar panel are connected in series or parallel to optimize voltage and current output. So you have to elaborate the first part, foldable frame supporting a plurality of solar panel. So how they are connected and what is the purpose of connecting? Purpose is to optimize the voltage and current output. So it becomes a logical claim. You can see here the improvement or Jepson claim is also being included. Components are not listed, not looks like assembly. It looks like an innovation. So your innovation must be highlighted in your claim. That's the way actually a techno-legal person should think of and can draft the patent application like this. So again, if I'm waiting for your questions, if you have any question, please ask. It would be good to answer your questions. Otherwise, I will shift to some more. Okay. So I'm shifting to another question. One question was about the amendment. Question was, under the Patent Amendment Rules 2024, what is the new time limit for filing a request for examination in India? And how does this differ for applications filed before the date of examination versus after? Mention the relevant rules. So under the Patent Rules 2024, the time limit of filing the request for examination has been reduced to 31 months from the earlier priority date. Means once you file, it is counted from the date of filing. Before 31 months, you have to file the request for examination. Previously, under old rules, it was 48 months. But there is also one lining, that is, if suppose if you have a worry about it, if you have filed your patent application before March 2024, the same 48 months timeline is applicable for you if it is filed before March 2024. After that, 31 months timeline is effective now. So it's about 2.5 years. Normally after publication in academics, people don't worry much about the examination. Remember, unless until you file the request for examination, patent office will not examine it. It will be remain published for 31 months. After that, it may show you as deemed to be abundant on the site also. So after 31 months, you may not be able to show it even as a proof. So it's better to file the request for examination and get it granted, because a granted certificate of patent is always far better than a published patent. So for granting a patent application, definitely sometime you may need the help of IP counsels, patent agents, but it's worth to do because grant of patent is actually considered everywhere for rankings, for everywhere. So that is the way actually we do. So we can take some questions if you want. I'm finding all your introductions. That is really good to receive the introductions. Like so many people from like all over India have joined this conference and attending. It's really a kind of very good, hopeful for all the patent aspirants that you all are so much enthusiastic. You can ask the questions, or you can later on also you can like give your questions to Dr. Rahul Kapoor if you have something in mind. We can take up your question later also, and I'm always happy to answer your questions. So normally you can see that model answer or arguments of patent application must be based on prior art, because the first query in the patent application always it's about the novelty. So always compare features of prior art with the claims and isolate the difference. Make tables, patent cited 1, cited 2, cited 3, and your own patent and how it is better in terms of single component, single outputs, and in that basis argue. Essential features sometimes are essential for every one. In standard essential patents, I have taken one thing that sometimes we need something as a core in our invention. So do not argue on that. Just find out what is different, how you are making more technically better. You should have a flexibility to amend the claims if it is falling in infringement, or covering more, or not explicitly reciting the distinguishing features. You should be able to amend, and you should always amend in such a way that your claim must not be so constricted, because you always have to go for licensing, and companies will take the license from you only when they will find it more profitable. So try to incorporate the features, but also not with infringement. So it's an art. This art will come with interest, with practice, and with help of the IP literatures. I'm skipping some of the trademark. I think you might have some like curiosity for Trademark Act also. For that, we can definitely help you out in future too, if somebody is trademark aspirant, because that exam is also tough to be cleared, and that has also a good future in terms of revenue, in terms of jobs, in terms of entrepreneurship or freelancing like this. So thank you so much. Thanks a lot for the patient listening, your questions, your answers.
Yeah, maybe there's one question. I think it has come. Gautam Dalvi, each paper has specific question pattern.
Yes. Actually, in paper 1, you will find different kind of questions. Some questions would be a 1 mark, 2 mark, 4 mark. Some are like assumption based, means you will be given 4 answers and you have to select one. So that is a case, means like a kind of reason assumption, kind of critical case study, kind of where you need to have some kind of logic. So that's why I told you in paper 1, for questions for 1 mark or 2 mark, you can you can skip true or false. Some analysis is there, and sometime more than one answer is correct. So in that way, you have to apply some logic, some kind, because if more than one answer is correct, or 3 answers are correct, even 4 are correct, then in that case, you need to have some kind of time to focus on that. So yeah, definitely the pattern of question is there. Possible you can go through the earlier question paper of patent agent exam. You can see that yes, it has a demarcation. It will find out your memory, it will find out your logic, it will find out your reasoning, everything in paper 1. And in paper 2, some question answers would be there, but that are based on case studies basically. They will ask you some short questions like in beginning, and later on there would be a full exercise of patent drafting. So some question answer followed by patent drafting in paper 2. So it would be a little bit lengthy paper. So I suggest that your answers, question answer, you should definitely answer in beginning. Try to quote some section rules if you remember. If you don't remember, don't skip the questions. Always answer the full paper. Write the technical part, write the knowledge, whatever you have. And in drafting, at least save some time, because I already told you that in drafting, you need to have at least 15 minutes, 15-20 minutes to read the patent application given to you. And then I think after you understood the total invention, it will not take more than 10-15 minutes to write the answer. So normally people, what they do, they make haste in reading. Later on they write again, go back to reading, and then again come back. In that way your patent means like your claims will not be drafted well. I always suggest first understand and keep 15 minutes to write if you are a fast writer, or keep 20 minutes to write if you are a fast writer, but manage your time in paper too. It's really difficult to manage time. Give less time in answering the short questions. Do not give much time. Keep your time for patent drafting, because that is normally 20 marks question, so you need to score well there.
Ma'am, two questions if quickly we can take, then we can conclude. So if amendments is made in claims or any other part of specification, is the application, can it be published for second time?
No, actually the system is that once you file a patent application, you can go for expedited publication by form 9 and fee of 2500. It will be published in a week or 15 days. That's an option. Another, if you don't opt for it, it will be automatically published after 18 months. Now the point come about amendment. Whenever you feel that you have done some incremental innovations after publication, clear. But before the patent examination, before the grant actually, even after examination, you can file the patent of addition. Patent of addition has half of the fee of patent application. Like just at 800 rupees, you can file the patent of addition and you can add something in your innovation. But it should be added in such a way that it will not change the innovation totally. Suppose I have made a laptop and in that I am adding some feature but not changing the laptop's original features. So patent of addition can be done. That is a great feature before, and it will expire along with your original patent application. It will go hand in hand with that, and you will have the equal monopoly right as your original patent application. So patent of addition is a very good way. Explore it. If you need any help, we can help you out in that. But go for patent of addition. You cannot amend the patent application. Yeah, clerical errors can be amended. Some errors like name of innovator, some address change or something could be amended, but technical part cannot be amended after filing complete specification.
Okay, ma'am. Last question.
Yes.
Is hardware compulsory for 3K related inventions?
Okay, that's a good question. So 3K is basically for algorithm, business models, and mathematical models. So algorithms are copyrightable matter. Softwares are, programs are copyrightable, codes are copyrightable. For patent, you need a hardware, you need an object. So even Google and Oracle have made it like compended blocks, computing machines. Somewhere they have incorporated their digital softwares in the form of a hardware. So that hardware become patentable. As you know, CRI guideline came and lot of support are there in terms of software patenting, but companies have still a litigation bar because section 3K always will reject your patent application at first. Now normally the companies take up the CRI guideline, go to the courts, and there are certain kind of exemptions given in new CRI guideline which allows the useful software inventions to be patentable. But in that case, you should have a software that is owned by you only, not taken by anybody else. And even the standard essential patents that become a part of this, like you cannot claim that if you have your own invention, then you can definitely have the software. Otherwise, section 3K will always come in algorithm and softwares. So you need a hardware, definitely.
All right. Thank you, everybody, for your questions. Thank you to the audience for attending for more than 2 hours. So thank you very much, ma'am, for yet another great session. I think many people are studying in bachelor degrees. So probably this year, if they don't appear for this exam, it is still like they got an impression. They might, in the future consider a patent agent exam. But yeah, we have a course which is taken by ma'am, and it is active. It's still one of the best courses in India, you can say, to prepare. And also in November, I was talking to ma'am that we will do a boot camp for the preparation of the exam aspirants in January. So thank you very much, ma'am. Thank you so much.
Thank you for the audience. Thanks for your like acknowledgements. Thank you so much.
Thank you very
Signing off.
much, everybody.
Bye.
Have a great evening. Bye bye.